Hey everyone, you've probably heard me wax poetic about how important it is to have an idea of a few practice areas that you're interested in practicing as a lawyer before you go to law school. But what exactly are practice areas in law? I get questions all the time about family law, international law, entertainment law, and while those are certainly practice areas, there's a lot of different ways to practice law within those practice areas. And how do those practice areas relate to when larger firms ask you, do you want to be in litigation or corporate? So here goes part one of my semi-comprehensive overview of legal practice areas. Let's start from the basics. There are three major buckets of practice areas: litigation, corporate, or sometimes called transactional to distinguish it from the colloquial use of the term corporate law, and regulatory, or compliance. I call these three practice areas buckets because all the other practice areas that we talk about, criminal law, environmental law, M&A, will fall into one or more of these buckets, but more on that in a later video. For now, let's just focus on these three buckets, and for this video, I'll be focusing on the first, litigation. Litigation is probably what you think about when you think about being a lawyer, going to trials, yelling, "Objection, Your Honor," cross-examining witnesses. It's what you did in mock trial or moot court if you did those as extracurriculars. At its core, litigation is about disputes. Some disputes, but not all, lead to trials. And even if you do go to trial, there's a ton of work that happens before the trial called pre-trial. And even if you do get to a verdict or a decision from the court, there's a lot of work that comes after too, potentially, called post-trial, which includes appeals to appellate courts. Because of its public nature, the inherently performative aspect of speaking in court, and the possibility for cases to be appealed all the way to the Supreme Court of the United States, litigation can seem like a really sexy practice area. We've seen certain lawyers become basically celebrities after litigating high-profile cases. Robert Kardashian, Camille Vasquez, David Boies if you know him. And while many Americans can't name all of the Supreme Court justices, they and their clerks are low-key celebrities in legal circles. You probably already have a good idea of the trial part of the litigation, but what you don't see is the significant amount of pre-trial work that goes into every trial. While certain practice areas go to trial more often than other practice areas, on the whole, most court cases are resolved during pre-trial. When a dispute arises between two parties, maybe two people who got into a car accident, maybe an employer and a terminated employee, maybe two companies where one company started buying the other company and then backed out. The first thing that usually happens is the aggrieved party sends a cease and desist letter or a demand letter or some other sort of letter to ask the other party to stop doing something, start doing something, or for money. Here, the dispute could end. The receiving party could decide to stop doing whatever it is that they were doing or give the money to the aggrieved party in exchange for the aggrieved party dropping the matter. And then that's it. Matter closed, dust your hands, on to the next one. But if party B doesn't agree to party A's demands, or party B itself likely has grievances against party A, party B can just choose to ignore the letter entirely or write a letter in response essentially saying, "We dispute the allegations in your letter dated blah blah blah," which is basically the lawyer way of saying, "Come at me, bro." Then the parties essentially play a game of chicken. Will a lawsuit be filed in court? If party A decides to sue, they'll have to file a document called the complaint with the court. The complaint, which you'll learn in law school, has to have certain information and facts in order to be complete or well pled. This document is essentially a plea to the court to take up the case and use state or federal powers in order to adjudicate the dispute. Litigators will ask their clients for interviews or other documents to use as evidence in drafting the complaint. After the complaint is filed with the court, party B will receive a copy of the complaint, essentially alerting them that they are being sued. They will then have a certain number of days to draft an answer, which is a document that has their answer to the complaint. In order to do so, party B's lawyers will have to talk to their client for interviews and to get documents that they can reference in their answer. In the answer, party B's lawyers can ask the court to dismiss the complaint entirely because the complaint is missing certain information, or even if the allegations were true, it's not a matter that is appropriate for the court to take on. So now we're at the stage where there is a lawsuit, but we're not even close to a sexy trial that you see in media. If the court doesn't dismiss the case, then we go full steam into pretrial matters, which are a ton. You would think that most of a litigator's work is trial work, but no. Pretrial work usually takes up much more of a litigator's time, and because attorney fees are so expensive, there is a huge incentive for the parties to settle. Sure, maybe party A is suing party B for $1 million, but if attorney fees for going to trial are going to be at least $2 million, then settling for $750,000 all of a sudden seems like a bargain. There are a lot of pretrial matters that could be addressed, but at the more junior levels, you're probably going to be spending a lot of your time on something called discovery. The purpose of discovery is to get evidence and potential evidence from wherever you can to support your case. Basically, all of the litigating parties, party A, party B, will send discovery requests to each other, but also to third parties who might have information that's useful to the case. Lawyers, of course, draft these discovery requests. So now you've sent out discovery requests, and you've also received discovery requests from the other side. But you don't just give the other side all of your documents. That would be crazy. You should always know what you're sending to the other side before it goes out the door. So how do you do that? You have to review all the documents that your client has, aka document review, or doc review for short. When I first started at a law firm as a litigator, we actually got pulled out of orientation because there was an emergency doc review that had to be done immediately. We immediately got briefed on the doc review that needed to be completed, and then I spent the next 5 days doing 12 hours of doc review a day. And I remember thinking to myself, welcome to big law. It's funny because as I got more senior, I actually kind of missed doc review. When you start a doc review, you'll get an information packet. I like to call them document review protocols, but I'm sure they can be called whatever, which will give you a description of the case so you have an idea of generally what you're doing, key terms that you might see in documents, particularly industry-specific terms, and an explanation of the coding panel, which is the most important part. The coding panel is a panel on the side of the document review platform that you're using, and it'll look something like this, where responsive A and responsive B are tags that you can use to denote that whatever document you're looking at is responsive in accordance with the guidelines in the document review protocol. For example, maybe for a document review protocol for the Jeffrey Epstein case, responsive A would be for documents that mention one of the plaintiffs suing Jeffrey Epstein, and responsive B for documents could be whenever there are mentions of plaintiffs having a private meeting with Jeffrey Epstein. Non-responsive is marked when the document is not relevant to the case at all. The other tags denote other characteristics about the document, including my favorite, hot document, which basically means that you have found the needle in the haystack and you think that this document is really crucial to the case that you're making or really crucial for the case that you're trying to defend against. These tags help the second level reviewer, maybe a peer, maybe a more senior associate, maybe a partner, orient themselves around the documents and get a full sense of the story of the case from the documents. As you get more senior, you don't do as much first level review unless something really urgent has come up, and you do a lot more second level and quality check QC reviews, reviewing all of the responsive documents to try to get a sense of the story that I talked about, untagging documents marked responsive if they actually aren't responsive, and spot check the documents marked non-responsive to ensure that the reviewer didn't miss anything and truly has a good understanding of what is relevant and not relevant to the case. And of course, if you're seeing a pattern or confusion among reviewers, then it's up to you to clarify the review protocol and make sure that all of the reviewers are on the same page. This whole process of discovery can take a long time. There can be hundreds of thousands of documents to go through, and before you even start collecting documents, you can have dozens of interviews with people to try and discern where are the best places to look for potentially relevant documents. Doc review is all about the process, and when you start running your own doc review as a mid-level associate, project management and organization skills play a much more important role than legal skills here. Not saying that legal knowledge isn't needed, because you certainly do need legal knowledge to know what search terms to run in the documents, but project management is a large part of doc review. More senior associates will also get the opportunity to negotiate with opposing counsel about search parameters for the documents, such as dates, keywords, and the like. And the idea is to agree about what a sensible universe of documents to review looks like. If the discussions called meet and confers ever fall apart, the parties can certainly petition the court to get involved, but courts generally hate being dragged into discovery disputes. Okay, that was a lot about discovery, sorry. It's just such a large part of being a litigator that's also underrepresented in media depictions of being a litigator. As discovery goes on, other pretrial matters might be happening in parallel, such as petitions to the court called motions, asking for certain procedural things. You can file a motion for summary judgment, which is asking the court to rule immediately on the case because of XYZ reasons and evidence, which could end the case immediately. Or a motion to sever, which is when co-defendants petition the court to have separate trials for them. This is what happened in the Theranos case with Elizabeth Holmes and Sunny Balwani. Or motion to certify a class, which is a necessary prerequisite to a class action and requires a showing that your case meets all the requirements in accordance with the Federal Rules of Civil Procedure, which, yes, is a book and is just a book of rules. I'll link to the Federal Rules of Civil Procedure below, which is a required 1L class, and that should give you a sense of the types of rules that you'll be learning in law school. You can file a lot of motions, and with every motion, you'll usually file a brief in support of that motion, which is a legal argument for why your motion should be granted and likely attaching exhibits, documents, affidavits, and other things that you might have found during discovery. Opposing counsel might agree with you and just join your motion, or if opposing counsel disagrees with you, they'll write a response to your motion and attach their own brief in support of whatever they want to happen with a motion. This back and forth between the attorney, opposing counsel, and judge is called motion practice. And sometimes judges will ask attorneys to have oral arguments in order to help the judge decide how to rule on a motion. This then leads to the sexy part of preparing for oral arguments and getting to speak on the record in court. Other pretrial issues include picking expert witnesses and getting them to submit statements, arguing over which state and/or court, called venue, is the most appropriate to adjudicate the case, and taking depositions. You've probably heard the term deposition before. Depositions are when attorneys ask questions to witnesses on the record after they're sworn in under penalty of perjury. It's as if they were taking the stand, but they're not actually taking the stand in front of the judge, because it's much more efficient for the court to have these questions asked before they even get to trial. You know those jaw-dropping moments where a witness on the stand says something and then everyone in the courtroom gasps? Yeah, those don't really ever happen in court because most, if not all, the witnesses were deposed before trial. Your job as the litigator at trial is to know exactly what your witnesses are going to say before they even say it. Sure, there are some moments where witnesses might say something different than they said before and contradict themselves or be caught in a lie, but those instances tend to be a rarity rather than a common occurrence. We've talked for this long and we haven't even gotten to the trial yet, because that's usually an accurate depiction of what being a litigator is like. Usually a ton of work and potentially years of pre-trial work before we even get to the trial. If a case does go to trial, that's when lawyers do all the things that you see on TV: prepare witness lists and exhibits, conduct opening and closing arguments, yell objection, all of that. It's exciting, yes, and a lot of the litigators that I know all found trial to be incredibly fulfilling, even if it means that they didn't sleep for a month straight. But the trial that you see is only the tip of the iceberg when it comes to what being a litigator is about. Then, when the trial is over and there is a verdict from the jury or a decision from the court, litigation could still continue. A party who's not happy with the verdict or decision can appeal the verdict or decision, and that sets off a whole new series of motions and filings with both the trial court and the appellate court. You can be called to present oral arguments for whether the appellate court should take on your case. You can file an emergency motion to halt the real-life impacts of a decision. It's a lot of what we talked about with motion practice previously, but on the appellate level. A lot of attorneys I know love appellate work because it's mostly writing and oral arguments without the drudgery of discovery, because no new evidence can typically be introduced during an appeal. Everything I talked about related to discovery, yeah, you can mostly ignore all of that for appellate work. This also makes appellate work a little bit more competitive to get into, and most appellate attorneys have usually done at least one judicial clerkship, usually with an appellate court. In addition to trials, litigation also includes going through this dispute resolution process in front of other decision makers, like arbitration, which can be really similar to trial work and trial preparation, except it has different rules and is on a more expedited timeline, usually. There's also work such as presenting cases to mock juries, going through mediation with a counterparty, and going to trial in front of the ITC, the International Trade Commission, for certain patent-related disputes. Litigation also includes responding to government or regulatory investigations or inquiries, such as a DOJ investigation for violation of antitrust laws or an FTC investigation for violation of consumer protection laws. When a company receives a notice that they are being investigated by a government agency, you as the attorney have to conduct an internal document review to figure out whether the government's allegations hold any water. You'll conduct a document review and do interviews to gather the necessary information so you can prepare a letter response to the government. The goal is to convince the government that there is really nothing to look at here and they should move on. The process is very similar to the litigation process that I described before: document collection, document review, search terms, all of that. Except there isn't a judge yet, and you're trying to convince the government that they should drop their case. Because of this unique posture, the tone also tends to be a bit more cooperative with government lawyers, whereas in civil or criminal cases with opposing counsel, the tone can primarily become an exercise in saying, "Your Honor, opposing counsel is stupid," in as many ways as possible. If during your own discussions with your client or document review, you find out that there may actually have been a legal violation, that's when you start talking with a government agency about ways to settle the case. Usually a civil penalty and ongoing monitoring, but in some cases, you just go to trial against the government. And there we have it, a semi-comprehensive overview of litigation. Now, who is litigation best suited for? Litigation is great for those who are, or who can be, really detail-oriented, because there's so much proofreading and site checking that needs to be done when you're preparing to file a document with the court. Filing papers with the court that has typos or just contain wrong statements is really, really embarrassing, and if you do that, you'll definitely get a very stern talking to. As I'll talk about in my next video in the series, corporate law is a little bit more lax when it comes to things like typos and cites. Litigation is also great for those who love digging through documents to find the story. In this way, it's also great for people who love the idea of being an investigative journalist. Of course, litigation is great for people who love performing or public speaking, or even if you don't love it now, you have aspirations to love it in the future. Just be aware that some practice areas, such as high-stakes securities class actions, tend to go to trial a lot less less, so there will be a lot fewer speaking opportunities. In fact, most lawsuits involving corporate entities tend to go to trial much more rarely. In big law, it can be common to be a 6th-year associate and still have never gotten the opportunity to speak in court for a paying client. There's plenty of opportunities in pro bono cases to do this, which is why if you are a litigator, you should definitely be doing as much pro bono as you can, because those are the cases that'll really give you the opportunity to hone your skills. There are some practice areas for which trials are more common though, which I will get into in a future video. Lastly, I want to clear up the misunderstanding that the hours in litigation are better than the hours in corporate. Litigation has a different ebb and flow, that's for sure. But having to do an emergency doc review after day 1 of mediation because opposing counsel brought up some surprise new narrative is just as bad in terms of hours and urgency as pushing up the signing date in an M&A. Trial itself is also a ton of hours and can span over multiple weeks, whereas corporate matters tend to be shorter sprints. I'll talk about corporate law in my next video, but the point is that you shouldn't pick your practice area based upon what you think is going to be a lifestyle practice area. There isn't really a reliable lifestyle practice, as all practices can get pretty busy depending on the time. Work-life balance in law is dictated much more by what type of employer you have rather than practice area. I'll talk more about employer types in a future video as well, but the point is, do not pick a practice area because you think it will be a lifestyle practice. Okay, that's all I have for litigation. If you're a litigator and would like to share your experiences, please drop them in the comments below. I always love hearing about how many different ways there are to practice law. And be sure to subscribe when the next video in the series about corporate law drops next. Thanks for watching.